A very good day to our lecturer. So, on behalf of Firm 13, for the purpose of today's legal ethics project paper, we will be having a presentation on the topic of exploring potential conflicts of interest in conveyancing, whether is it ethical for both vendor and purchaser to retain the same lawyer. So, conflicts of interest in legal ethics are a complex ethical dilemmas that pervade the legal profession, which represent a delicate balance between an attorney's professional obligations and personal financial interests. So, to the root or core of it, a conflict of interest arises when an attorney's private concerns or affiliations clash with their duty to provide undivided loyalty and zealous representation to their clients. So these conflicts can manifest in various forms, with concurrent, successive, and imputed conflicts being the primary concerns. Moving on, we have included a case citation on Ng Siu Lan and John Lee Tsun Vui and another 2017, which this case the judges had contended that a lawyer owes a duty to his client not to for another in a situation where there would be a potential conflict of interest. If such a situation arises, he must then decline to act for one of the other. Such a conflict will invariably arise where one firm of solicitors represents the two parties on the opposite sides in a litigation case. Next, coming back to our today's present project paper issue, the question is whether it is ethical for both the vendor and purchaser to retain the same lawyer, raises significant concerns about conflicts of interest in today's legal representation. So, ethical norms within the legal profession prioritize undivided loyalty and zealous advocacy for a client's best interest. When a lawyer simultaneously represents both vendor and also the purchaser in a transaction, inherent conflicts may arise as the interests of these parties often diverge. So, the potential for conflicting priorities, confidential information, and competing goals possess a serious risk to the attorney's ability to provide unbiased advice and representation. Attorneys must thoroughly assess the situation to ensure that their duties to both clients are not compromised and that they can maintain the necessary objectivity and loyalty required by ethical standards.
Thank you, Riana. Assalamualaikum. My name is Sarah Amelia binti Muhammad Ihsan George, and I'll be presenting about the impermissibility of conflict of interest. So, in Malaysia, it prohibits the conflicts of interest in order to maintain ethical standards. By referring to Section 94, Section 3 of the Legal Profession Act 1976, it defines that misconduct as a conduct or neglect by an advocate or solicitor in a professional capacity constituting significant impropriety. By referring to the case of Ghazali Abdullah versus FGF Plantation Malaysia Central Berhad, employees are required to avoid conflict of interest and declare them to their employer to protect the employer's interests. By referring to Rule 3, advocate and solicitors ought to refrain from taking on a legal dispute that may disgrace them. Next. Thank you.
Assalamualaikum. My name is Allysya Qisty and I'm going to explain the representation of multiple parties in conveyancing in Malaysia and UK. In Malaysia, in some cases, it can be seen that the purchaser and vendor share the same solicitor to assist them in property transaction. This is because some parties think that it can reduce duplication and reduce the wasting of time because the letters and paperwork would not need to be sent back and forth. Thus, when the law firm represents the purchaser, it only assists the vendor. They might not entirely in the vendor's best interest because they represent the purchaser in this transaction or vice versa. When they hire one solicitor for two parties, the solicitor will not focus or give their best interest to the client. So due to this, some legal firm may not do their due diligence on the transaction. Thus, it might not avoid the fraudulent activity or money laundering. So from this, the effect is that the developer or proprietor or administrator or executive may still have the title to the property. This shows that they might not perform their diligence in the property transaction, hence the client will not be properly advised. The relevant rules in this issue is Rule 3 of the Legal Profession Practice and Etiquette Rules 1978, which provides an advocate and solicitor shall not accept a brief if he is or would be embarrassed. In Rule 4, it provides that no advocate and solicitor shall accept a brief in a case where he knows or has reason to believe that his own professional conduct is likely to be impugned. In Rule 5, it provides that no advocate insister shall accept a brief if difficult for him to maintain his professional independence. In Rule 6 of Bar Council rulings provides that a lawyer is prohibited from representing both purchaser and vendor in the same transaction. Thus, this rule set out clear provision on separate solicitors for vendors and purchaser for property transaction. Thus, failure to abide these rules will give a negative impact to solicitor and the law firms. Moving on, for United Kingdom, many individuals, both clients and solicitor, believe it is beneficial for some convincing solicitor to work for both of the seller and buyer in convincing, because convincing may be carried out faster since letters and papers do not need to be forwarded back and forth, and price may be lower. This is a practice called dual representation. The Solicitor Regulation Authorities (SRA) Code of Conduct specifies that acting for both buyer and seller on land transfer for value is an indication of a possible conflict of interest. However, it says that a solicitor may represent for both of the seller and buyer as long as the solicitor has clarified the pertinent concerns and potential hazards to the clients, and they are fully aware of the concerns and the hazards of the clients, have given their consent in written form. The solicitor finds acting for all the clients is reasonable and in their best interests. The cases on that are on point in this issue is Johnson and Marriott, where the Court of Appeal was not unanimously in stating that there is not no general principle that a solicitor has acted for a client in particular matter cannot under any circumstances act for the opposite party in the same manner. The court also stated that it depends on the circumstances of each cases. And in the case of McDonald Estates and Martin, the court concluded that firms should be restrained from acting for the second client unless, on the basis of clear and convincing evidence, that all reasonable measures have been taken to ensure that there will be no disclosure.
In certain circumstances, the Bar Council allows a firm representing both the purchaser and the purchaser financier. One party will act for the execution of the SPA and another acting for the loan documentation. There are some recommendations to avoid conflict of interest. First and foremost, all parties involved, including the vendor, purchaser, and purchaser financier, should be fully informed about the dual representation. Secondly, the firm should obtain informed consent from all parties involved before proceeding with dual representation. Next, the law firm should implement robust conflict management procedure to identify and address any conflicts of interest that may arise during the course of representation. Last but not least, while dual representation is allowed in certain circumstances, the party involved, especially for the purchaser and the purchaser financial, should still be encouraged to seek independent legal advice if they have concern about the arrangement.
As a conclusion, in a convincing transaction, it is crucial that each party must choose his or her own solicitor and be represented. A solicitor will safeguard his client's rights and interests at all times, from the moment the terms and conditions of the sale and purchase agreement are drafted to the time the transaction is completed. If the vendor chooses not to be represented by a solicitor, he is responsible for ensuring that the transaction is completed within the time range specified in the sale and purchase agreement. And it can also be concluded that Malaysia and UK practice in conveyancing is different, whereby Malaysia mostly still hires separate solicitors. At the same time, the UK opts for dual representation to save time.